Thank you for joining us today. Family law and family law issues in the pandemic is what we're talking about, and we're joined here by Linda from Hopgood Gannon. My name's Sammy. I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. Before I start, I would like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin or Brisbane, that's the Turrbal and the Yagara people. I wish to pay respect to their elders past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. I would also like to pay my respects to my people and elders of the Gumbaynggirr Nation, Northern New South Wales. My thoughts go out to them during these difficult times, and as this webinar is being viewed by people across Queensland and Australia, we also pay respect to the traditional owners throughout the country and extend a very warm welcome to any First Nations people listening today. As we said today, we're pleased to welcome Linda, who will be talking to us about the challenges that we continue to face within the family law context 2 years into the ongoing pandemic. I'll let Linda tell you a little bit more about herself and the topic, obviously, when I hand over in a moment. But before I do that, just some quick housekeeping. Today's webinar is being recorded, and we'll have the recording available to download later on today or tomorrow. The PowerPoints and other materials have been emailed out to everyone who registered, providing your email address was correct, and they will also be available to download from our website, and they are in the handout section of the GoToWebinar control panel. We encourage you to ask questions. You don't need to wait until the end to remember them. Feel free to type them in as you think of them in the control panel, and I'll read them out at the end. I will hold them over until the end of the presentation, as I said, but feel free to type them as you think of them. And now I'll hand over to Linda, and I'll talk to you again at the end of the session. Thanks, Linda.
Welcome, everyone. And just to echo Sammy's sentiments, I do appreciate your patience with the tech issues we had last week. But it seems even with blood all around us, we can still proceed with this today, which is wonderful for everyone. As Sammy mentioned, I'm a lawyer at Hopgood Gannon. I've been practicing in family law for almost 20 years. I'm a special counsel there, and I am also an accredited family law specialist. And today, the topic of discussion is the impact of COVID-19 and family law. And those impacts, although in some areas are easing, are certainly still a tricky area for us all to navigate. So the focus of today's presentation is looking at COVID-19 and working through some of the challenges that it's presenting for clients, family lawyers, and also domestic violence service providers. We're now often faced with questions that, but for this pandemic, we rarely had to think about, let alone give clear, concise, timely, and accurate advice on. So that's a bit of a change for us family lawyers in particular, and I suppose the other challenge for us is keeping on top of all the changes that keep happening in terms of vaccination and isolation, testing requirements and things like that. So the first topic today is vaccination, and that's largely focused on what happens when parents can't agree to vaccinate their child, and can a parent's time with their child be suspended as a result of that parent being unvaccinated. So the focus is on vaccinating children and also unvaccinated parents as well. In terms of the second topic, I'll be looking at parenting arrangements and what happens if a parent or a child needs to isolate, which really in turn often means that they're unable to comply with parenting orders. And what do we do in that situation? The final topic is really looking at working from home and the impact of that on victims of domestic and family violence. And also, just as a bit of an addition to that topic, what are the obligations on employers and what can they do to make working from home better and safer for victims of domestic and family violence? This, although is under an umbrella of a COVID-19 topic, is actually a very current issue. I myself am working from home for possibly the next couple of weeks as a result of the basement of the building in which I work in the city being flooded. So I expect that there will be a lot of people who have found themselves unexpectedly working from home this week and potentially next week as well. So it's a very current topic, and it's not limited to COVID-19. So looking at the first topic of vaccination, and can I just say before I go into this, I found this very interesting as I was researching it, possibly too interesting for something as simple as vaccination, but in any event, it was a very interesting topic to take a look at. And at the moment in Australia, the COVID-19 vaccination is now recommended for children aged 5 years and older. That's fairly recent. Before that, I think the minimum age was 11 or 12. So it's now gone into this much younger children, which has created a hot topic, if you would call it that, and definitely a source of conflict among separated parents. So what we've got at the moment is health directives, which are to the effect that COVID-19 vaccination is safe and effective for children aged 5 years and older. However, there are some mild and common side effects which most people are aware of. Certainly, they're notified of those when they go and get the vaccination for their child. Separated parents in particular find it difficult to agree on whether the COVID-19 vaccination is indeed safe for their child or not. Many parents worry that it's been rushed out to the market and they're adamantly opposed to it. And the reality is, at the moment, no one really knows the long-term effects of the vaccination. So family lawyers are often faced with scenarios where one parent is fully supportive of their child receiving all recommended vaccinations, whilst the other parent is against vaccinations of any kind, or is opposed to a specific vaccination or immunisation. And the COVID-19 vaccination certainly falls within that particular opposition for the vaccination. A common question that we're asked at the moment by parents is whether they can individually or by court order have their child immunised or vaccinated without the consent of or in defiance of their former partner. So can they go and get their child vaccinated even if their partner doesn't, or their former partner doesn't agree to it? So the starting point for this question is what we call the presumption of shared parental responsibility. Unless and until a court varies this, parents are taken to both have parental responsibility for their child. This means that each parent has all the duties, powers, responsibilities, and authority which by law parents have in relation to children. That shared parental responsibility obliges parents to consult with each other and make a genuine effort to come to a joint decision in relation to any major long-term issue. That type of issue relates to the care, welfare and development of the child, and which are of a long-term nature. So not day-to-day decisions about what the child will wear today, what I'll put in that child's lunchbox. It is a very specific long-term decision, and the child's health is regarded as a major long-term issue on which parents are expected to consult with one another and try to reach an agreement. This includes decisions about vaccinations and immunisations. If parents can't agree to vaccinate their children, they can ask the court to make that decision for them. They do this by filing an application together with an affidavit which sets out why they either want the child to be vaccinated or why they're opposed to it. The Federal Circuit and Family Court of Australia, which is the long term for our family court system here, it has the power to make an order that a child be vaccinated. That issue has come up in many cases before, whether the court does have a power to make that order, and they certainly do. In most cases, the court decides in favour of the parent seeking to have the child vaccinated, and usually considers that any potential risks of vaccination are greatly outweighed by the risk of harm from vaccine preventable diseases. Also considers that a failure of a parent to vaccinate exposes a child to risk of harm, and it also looks at the indirect benefits of immunisations to the community as a whole, which argues in favour of vaccination. In other cases, evidence can be provided to the court from experts and the child's treating GP and medical specialists that have essentially had a long-term relationship with the child. If those experts deem that there is a pre-existing medical condition of the child that makes it unsafe for that child to be vaccinated, and that the vaccination could potentially be harmful. One of the areas I think that would be taken into account in this would be previous adverse reactions to vaccinations and immunisations when they were younger. Those seem to be very real concerns that the court is taking into account in relation to whether the vaccine is going to be safe or not, based on their reaction to previous vaccines. Ultimately, the court will make the decision regarding vaccination based on the best interest of the child. So if they consider it's in the child's best interest to have the vaccination, they will generally allow that to happen and make an order for that to happen. If they've received evidence and that evidence is compelling enough that says it's not in the child's best interest to be vaccinated, then they will not make that order. I've included a couple of cases, again, which I have found quite interesting. The first is Dacombe and Paddison, which is a case that was a decision that was awarded at the end of last year in December. In this case, a father unsuccessfully appealed against an order authorising the mother to vaccinate the party's child against COVID-19. So essentially the parties had agreed and consent orders were made allowing the mother to vaccinate the child with the Novavax vaccine in the event that this particular vaccine was approved by Australian authorities at the time when the child was of an age when they were eligible to be vaccinated. If that particular vaccine was not approved, then Dad was able to pick any other authorised vaccines, and then if he didn't select a vaccine, the mother was able to choose the vaccine. So these were consent orders, the parties agreed to them, they were sealed by the court, and they are orders. The father sought to appeal those on the basis that he never gave consent for the order to be made and that the primary judge lacked power to make the order. He referred to section 51 subsection 23A of the Constitution in arguing that the order imposed a form of civil conscription which was unlawful. That particular section of the Constitution forbids the Australian government from providing medical and dental services in such a way as to oblige parents to accept those services. So the father was relying on that section, saying that the government is forcing me to do this. It was found that the concept of that civil conscription did not fetter the court's power to make orders about children's medical treatment under the Family Law Act. And at the end of the day, the parties had actually agreed that the child should be vaccinated, and the consent order that they entered into only governed the manner in which it would occur. So I think the most compelling part was you had actually agreed to it, and now you're coming back to us telling us that you don't, and we're holding you to that consent order. Covington and Covington is a fairly popular case, again, a 2021 case, so we're talking right in the heat of the pandemic here. So, and while it doesn't explicitly deal with the COVID-19 vaccine, it does provide some guidance as to how the court deals with vaccines generally, and may in the future deal with the COVID vaccine for children. And I suspect that this case has since been referred to in many other cases in support of the vaccination occurring. In this particular case, the father wanted the 10-year-old child to be vaccinated and the mother disagreed. Interestingly, the child had not received any vaccinations up to that point. They went to court during the trial, which often does happen, I must say. They entered into consent orders, which provided for the child to receive all future vaccinations as recommended by the child's doctor or treating medical professional. The mother later sought to set that order aside, so again seeking to set a consent order aside that they had previously agreed to. And she got hit pretty hard for doing that. So not only did the court dismiss her application to have the order set aside, but it went on to amend the orders so that she was restrained from attending any medical appointments about the child's vaccination, and she was not able to contact any of the child's treating medical professionals insofar as the communications related to vaccines. Until the child was vaccinated, the court further ordered that the child was to live with the father and spend time with her to ensure that she didn't complicate the process and cause the child distress. After the child was vaccinated, then it was able to return to the regular parenting arrangements, which was in fact that the child lived with her and spend time with the father. So the court took a fairly strict approach in this particular case and effectively excluded the mother from any involvement with the vaccine process, and indeed removed the child from her care until that process had been completed. That case in particular highlights and confirms that the court will only make an order if it's in the best interest of the child to do so. So they don't take into account parents' feelings or parents' beliefs or what parents want. It's really what is in the best interest of each individual child in each individual case. So notably in this case, the mother was not able to provide any evidence as to why the child remaining unvaccinated was in the child's best interest. And the father, doing the complete opposite to that, had expert evidence, relied on opinions from the child's medical professional and medical research that showed that a failure to vaccinate may expose the child to harm. His arguments were child-focused and were based on the best interest of the child. So the court can only make a decision based on the evidence before it, and it will only do so if it is deemed to be in the best interest of the child. Again, this case confirmed that the Federal Circuit and Family Court of Australia has the power to order that a child be vaccinated, and it further confirmed that once orders are made by the court, including orders by consent, the orders continue to be valid even if after the fact one party withdraws their consent. And this is on the basis that court orders, whether they're made after a contested hearing, whether they're made by a judge, whether they're made by agreement between the parties, are binding and enforceable until they are set aside by the court. Another case, this is pre-COVID, but also quite relevant to the current situation we find ourselves in, is the case of Duke-Randall and Randall. This is one, again, where the parties couldn't agree on whether to vaccinate their children or not. Interestingly, while the relationship was intact, the parents had agreed not to vaccinate their two children, but then after separation, the father changed his mind, became concerned for their health, and changed his position to support vaccinations. It ended up before the court. The mother argued that vaccinations should be classified as a special medical procedure. However, the court ultimately held that it is not, and that vaccinations are a common aspect of childhood as opposed to a special medical procedure. It was ordered by the court for the children to commence a catch-up vaccination program, which would ultimately see them fully vaccinated. So another case going back some 8 years now, again, supporting vaccination of children in the whole. The matter of Kingsford and Kingsford, this is an interesting one. It was 2012, but also relevant, very relevant, I suspect, for today, where the father secretly vaccinated the children without the mother's consent. There were no orders in place at the time of the vaccination, and therefore he wasn't in breach of any orders by having the children vaccinated. In any event, it did end up before the court, and despite the concerns about the father's unilateral decision and lack of consultation with the mother and seeking to obtain her consent, the court nevertheless determined that it was in the best interests of the children to be vaccinated. I suspect this is already happening a lot, and that children are being vaccinated secretly when they are spending time with the other parent. And the issue, and one of the challenges for us, is once the vaccine's in their body, what can the court possibly do about it? So, and then ultimately, unless there's compelling reasons not to, they probably would have supported the vaccination in any event. Turning now to unvaccinated parents, it's not an Australian case, but it's certainly a case which has drawn international attention, and certainly we in Australia have learned a lot about it. But it's a Canada case, and in this particular case, an unvaccinated Canadian father lost custody, and I put the words custody in inverted commas because we don't use that terminology anymore, but they have in this case, so I've kept it. So he lost custody of his 3 children after a judge ruled he posed a risk to his immunocompromised 10-year-old daughter. The judge also ruled that the children's mother could have the children vaccinated against COVID-19, despite the father's objections to this. And in making the decision, the judge said in her written decision that she was revoking the father's access with a heavy heart, but that the children must be given their best possible chance at evading infection from COVID-19. She also said it is no contest. The current science in the face of a highly contagious virus far outweighs the father's wait and see approach. She also dismissed the father's concerns about the safety of the Pfizer vaccine. And this case, as I've just mentioned in that last point, it's very relevant for us because it's still making a decision based on the best interests of the child, which is exactly how we make parenting decisions here in Australia. And on the same facts and on a case here, that decision could certainly be made. So it's relevant, I think, for that reason to just keep that one in mind. I've included some information over the next couple of slides in relation to the national COVID-19 list. And I thought it was worth mentioning how the court is attempting to deal with pandemic-related issues in a timely manner. And indeed, this information is relevant to each of the topics discussed today, and they would all fall under the umbrella of applications that could be filed on an effectively urgent basis. In normal circumstances, once an application is filed in the court, it can take 6 to 8 weeks for a first return date to be allocated. That sort of delay in the face of a pandemic, where issues are often urgent and require urgent judicial determination, is clearly unacceptable and can in fact put people at risk of harm. So the list was created to ensure that delays were minimised where at all possible. And the establishment of the list to deal with urgent applications filed as a result of the COVID-19 pandemic, particularly those involving family violence, it does show the responsiveness by the court to these issues and an acknowledgement that these issues need to be dealt with more urgently than others. So the list was created in April 2020, again, heart of the start of the pandemic, and it was a priority COVID-19 list. dedicated to dealing exclusively with priority family law disputes that arose as a direct result of the COVID-19 pandemic. And the overarching idea was it would help ease delays in the current system. That list is experiencing a rise in the number of applications involving disputes about vaccination of children. I suspect now that we have children from ages 5 and up being vaccinated, those applications have continued to soar in 2022. And I would hate to see what those applications would look like if they implement vaccinations from children much younger than that, which I understand is a possibility, and testing is happening for that. The court's also been presented with situations where one parent has stopped the other from seeing the child because they are unvaccinated, so the list deals with that. And as I've said, it's experiencing that steady rise in the number of applications related to vaccination. So the list, in terms of vaccination at least, is proving very handy indeed. I've included below on the next 2 slides some examples of applications that would be considered suitable for filing in that national COVID-19 list. I won't go through them all, but you can see from the headings, they're dealing with matters of family violence, where there's been a suspension of a parenting order due to a domestic violence order, which overrides the parenting order, and what happens in that situation, medical issues, vaccinations. It included travel arrangements and border restrictions, and that's, you know, where the parties were living in different states and there were difficulties with the child travelling between the residences. Certainly that's not as big of an issue as it was now that a lot of states have opened their borders, but it certainly was one of the reasons to be able to get a matter heard urgently. It included some financial and urgent maintenance orders. The next one is a big one right now. So you can file an application if there's been a failure to resume time between a parent and children in accordance with a parenting order or a parenting plan. So where parties have agreed to suspend parenting orders or a parenting plan due to these COVID-19 restrictions, but once those restrictions eased, there was a failure or a refusal to resume compliance with those orders. That happens a lot, and something that as a family lawyer and or an advisor, we need to be aware of what we can do in that situation. The last one, I'll jump to that, it talks about supervised contact, and you might be able to file an urgent application in this list to deal with if the current parenting arrangements involve supervised contact, but the contact centre is closed or the supervisor is unable to perform their role and the parties cannot agree on an alternative arrangement. I have a client at the moment and he spends time with his young child at his house, and a supervisor from a registered contact centre comes to his house and supervises the child 3 times a week. About a month ago, that supervisor advised everybody that she had got COVID, and that has resulted in a lot of time being missed between the father and the child. So what happened, the supervisor became COVID positive, then the child that she was there supervising, aged under 1 at the time, also caught COVID. Then that child's mother and stepbrother also caught COVID. So if you sort of put the 7-day isolation period on top of each of those, I think it was about 2 weeks before any form of contact could resume between my client and the child. And my client was, he didn't get COVID at all. So whilst it was frustrating from his point of view, there is nothing you can do about that. It's a fact of life at the moment that a lot of us are going to contract COVID-19 And you just need to be flexible and understanding, and most importantly, child focused in relation to the arrangements around that. Moving on to parenting arrangements and COVID-19, I've touched on that in some aspects under vaccination, but this is a more targeted discussion about that. So essentially what we have found, and probably comes as no surprise, is parents who can't cooperatively parent will find their parenting arrangements most impacted by COVID-19. Compliance with parenting orders at the moment is becoming more and more difficult amidst the pandemic. On one hand, you've got parents who are understandably concerned for their child's welfare, with fears that the children may be at risk of serious illness, both in contracting the virus themselves or transmitting it onto others at risk. And then you've got perhaps one parent refusing to hand the child over, and in doing so, finding themselves in contravention of a parenting order. So the first part of this is basically what can happen when you contravene a parenting order as a result of contracting COVID or the children having COVID. Contravention of a parenting order occurs where a person has intentionally failed to comply with an order, or they've made no reasonable attempt to comply with the order. Breaching a parenting order is considered an extremely serious contravention by the court, and it is dealt with, and the penalties can be of a quasi-criminal nature. So it's different to almost any other application in the court because of the seriousness of it. In the decision of Santa and Santa, this was a March 2020 decision. So again, right at the start of the pandemic when there was a lot of uncertainty. Interim orders in this matter were made in 2018 regarding the parenting arrangements for the children, and they included an order that the children spend time with the parties for half of the holidays. Nothing unusual there. However, the mother withheld the children from spending time with the father. He's on the school on the basis that his profession as a half school holidays, a specialist medical practitioner, was exposing him to a significant risk of infection and therefore exposing the children to COVID-19. The father brought a contravention application before the court, and the court was satisfied that the children should spend holiday time with him, and in doing so noted that the mother did not produce any evidence to suggest the children were at risk in the father's care. And the judge in fact commented, "I am not satisfied that there is any reason why the father should be tested for COVID-19, why he should isolate himself, or why the children should not be returned to his care." Another May 2020, so very early pandemic case, the matter of Paddison and Harmon. This is a case that was heard and determined when various state and territory borders were closed. When the Queensland borders were closed, there was an exception that allowed interstate travel to Queensland, provided it was in accordance with a court order. So for example, a parenting order that required a child to travel interstate to Queensland to see the other parent. So in this decision, the court was asked to decide whether the mother's refusal, due to her COVID-19 related concerns, to allow her child to travel from Adelaide to Brisbane to spend time with his father pursuant to orders, whether that was a contravention of those orders. So did she breach the orders made without having a reasonable excuse for doing so? And her excuse was, "I am concerned for the health and safety of the child travelling to Brisbane." When she refused to travel with the child to Brisbane to reduce that child's exposure to the virus, the father filed a contravention application. And in order for that application to be successful, he needed to prove that the mother had breached the orders without a reasonable excuse. The court, however, found that she did have a reasonable excuse for non-compliance with the orders and that her concerns for the health of the child were a reasonable excuse for her not flying the child to Brisbane Airport. I'm not sure if it was just Brisbane Airport that was the issue, but certainly that was noted in the decision. It's worth noting the time of the pandemic when this decision was made, because as restrictions start to ease, borders open, vaccination rates increase, confirmed COVID-19 cases decline, it's less likely that this sort of scenario, relying on health concerns for a child, would be considered a reasonable excuse in contravention applications, particularly now when back then children of any age were not being vaccinated, and now we have children eligible for vaccination from the age of 5. Looking now at isolation and the impact that is having on compliance with orders, it obviously is a very current issue. Presently, unless something has changed in the last week, which is entirely possible, but if you test positive to COVID-19, there is a requirement that you and anyone else in your household isolate for 7 days. The number of children and teachers isolating continues to increase now that schooling has returned to normal. I can personally vouch for that happening. My child's teacher has had to isolate, and she's had relief teachers for the last week and a half. There are children missing from all classes across the school because they're at home isolating. I must admit, it's making school drop-off a lot quicker than it usually is, but hopefully we do return to normal soon. So the rules around isolation and testing requirements, it continues to change, and that is making it difficult for high conflict parents to be able to reach an agreement if either they need to isolate or their children need to isolate. Basically, if one of them needs to isolate, then they all do. Everyone is expected to follow public health guidelines and directives regarding isolation, and that often means parenting orders can't be complied with. And it invariably results in one parent missing out on time with the children, such as the case that I explained to you previously of mine, where the supervisor caught COVID, then the child caught COVID, then the child's household caught COVID. And it did result in approximately 2 weeks of missed time. So it does happen. However, in most cases, parenting arrangements can continue, even with the current restrictions. Isolation is a little bit different. The current requirement to isolate for 7 days will certainly impact parenting arrangements. If you have court orders about parenting, or if you have a parenting plan, you should follow them unless you have a reasonable excuse not to. Reasonable excuse includes a health professional directing you and the children to go into isolation or quarantine, or travel being banned. So there's a lot of reasons that can be a reasonable excuse, but that's just some examples that are relevant to this area. If isolation does become necessary and that does impact on a parent's time with the children, the question that we are often asked is, how is this managed? What can we do? Firstly, from a practical point of view, where possible, the parents should try to follow the spirit of the orders and work with each other to try to find solutions that are safe and will work for everyone, including the children. I suspect I still have a job in family law because a lot of parents actually cannot do this, particularly those high conflict parents. What effectively should happen is that the parent in isolation with the child should inform the other parent as soon as possible of the isolation. They should provide medical advice and copies of any test results to the other parent. It will not surprise you that sometimes parents don't believe that a child in fact has COVID and that the positive test result has been manufactured. To avoid any issues arising there, provide a copy of the test result. Easy. They should also inform the other parent when the period of self-isolation is expected to end, so that there is a bit of an end date as to when they can start seeing the children again and how that will work. The parent in isolation should also try to be as flexible and reasonable as possible when making new arrangements. They should really try to help the children maintain contact with the other family members, phone, video, FaceTime, email during the period of self-isolation. Again, in the case that I had, the child was 1 year old, so none of those things were really suitable, and I believe FaceTime lasted for a total of 33 seconds before the child was distracted by an ant crawling on the wall. So that doesn't work for all ages. It certainly will work for older children. And lastly, and this is the one that creates the most conflict, I think, and dissension, consider arranging makeup time for when the period of self-isolation is over. In my particular matter, I believe we negotiated this over a period of weeks, and it probably involved about 10 letters exchanged between the lawyers, and we still don't have an agreement on makeup time for when the child missed out on time with dad because of COVID. So essentially, parents are encouraged to work through any changes with each other and come up with an agreement that if it is safe to do so, and all decisions and arrangements made should remain completely child-focused. Overall, parents need to approach the issue of isolation and missing out on time with children as a result with common sense and flexibility. No one is actively seeking to be infected with COVID-19, but it is likely we'll all catch it at some stage, which means it may continue to impact parenting arrangements for some time yet. If one parent does need to self-isolate and the children are with the other parent, the children should remain with the other parent for as long as the self-isolating parent remains in self-isolation. This is likely to cause parenting orders to change completely for that period of self-isolation. It might involve a complete change of residence for the children for up to 7 days. If disagreements arise, as I mentioned, parents are encouraged to try and work things out with help from a family dispute resolution service or a counsellor if needed. If they can't reach an agreement, or if it's not safe for them to communicate with each other, they can apply to the court for a decision to be made about the arrangements. And as I mentioned with that national COVID-19 list, this would fall within one of those cases that could be dealt with more urgently than others. Just to finalise on this particular topic, the court is bound by the best interests of the child, which means they won't force a child out of isolation to spend time with a parent. That question has been asked, nor will they force a parent out of isolation so that they can comply with orders. Moving on to the last topic now, and I am conscious of the time, and there are some slides at the end of this topic that I can skip over if needed so that we can get to your questions. But, and some of this, most of this indeed, will probably come as no surprise to all of you. But the impact of COVID-19 on victims of domestic violence has been significant. Reports continue to show that there has been an alarming increase in violence against women during the pandemic. The discussion today is focusing on the impact of working from home and isolation on victims of domestic violence. So now we're in this working from home scenario, and as I mentioned at the beginning, this is continuing even now because of the flood crisis. So working from home is changing how people work. So as well as changing how people work, COVID-19 has led to increased physical isolation, financial stress, increased levels of unemployment and underemployment, increased workload for many, increased alcohol and drug use, and the flow-on effect from a lot of that is an increase in domestic and family violence. For many people experiencing family violence, their workplace is the only safe place they have. It's also a space where arrangements can be safely made to leave a situation of family violence in their home. Working from home has now made workplaces unsafe for many workers. Working from home and other pressures associated with COVID-19 can change the safety and support needs of people experiencing domestic and family violence. With the security, socialisation and routine offered by attending work disrupted, domestic family violence abusers will have increased opportunities for coercive and/or violent behaviours. The tactics used by abusers, such as coercion, surveillance and isolation, could also include denial of access to outside services such as healthcare, all of which increases the dependence of the victim on the abuser. Or in work from home scenarios, the abuser can go on to sabotage work, create constant disruptions that reduces productivity and concentration. And if that productivity reduces to the point where it draws the attention of a supervisor, then it can have devastating consequences for the victim. Looking at the legal obligations as an employer, because I think this is very relevant, and it's not only relevant to employers, but also people who deal in that domestic and family violence space. Domestic violence is a workplace issue. Employers have a duty to ensure the health and safety of workers, minimise risks and consult with workers when they are working from home. The vital role of workplaces in preventing and responding to family and domestic violence is just as important when workers are working from home. And workplaces can assist their remote employees by raising awareness of the increased risk and keeping up regular communications. That last point, keeping up regular communications, is probably the best thing a workplace and an employer can do. It's also important to consider domestic and family violence as a risk factor in any work from home safety assessment, and to recognise that it may be dangerous or difficult for an employee working from home to tell their employer that they are experiencing or worried about violence or abuse. Specialist services remain the best option for expert advice on safety planning and emergency accommodation, but it's also recognised that accessing these services may be more difficult when the abuser is also at home. They don't have that safety of an external workplace to go to so that they can look into these things. They cannot do it at home when the abuser is also there. So employees, importantly, have the right to take family and domestic violence leave. They have the right to take personal and carers leave, and they have the right to request flexible working arrangements if they are experiencing family or domestic violence or caring for someone experiencing it. So employers have a legal responsibility to keep information about domestic violence confidential. This is part of keeping an employee experiencing violence safe. The only exception to breaching this confidentiality is to prevent someone from being harmed. So if there's an imminent risk or it's been identified that there is a risk of harm, then they can breach that confidentiality. So ensuring a safe work environment is still the employer's duty, even when staff are working from home. This is highlighted particularly right now. Employers should aim to have open and secure communication with staff, act in a non-judgmental manner, and ask the staff member, what can they do? What help do you need from me? And as I pointed out at the start of that slide, employees have rights, but it's important to let them know what their rights are and how workplaces can help. Some people might not know that they can take leave or that they can request other flexible working arrangements. So it's important that everyone in your organisation is aware of those rights and how you as their employer can help. one case that is in this space of employers' obligations